It's a blessed evening. Welcome to Bold Moves Radio. The show is Prudent Woman with myself, Rhulani Baloyi. We are excited this evening to have you joining us. You can all agree with me. The year it's over. I can't believe that today is the 23rd of October. And the show started somewhere the beginning of May. So we have been together for quite some time, and I would like to appreciate each and every person who continuously join us, and those who, when they have missed the show, they go back and listen to the show. That to me, it's so encouraging to know that there are people who are here, and it gives me the strength to continue and go out and seek for people whom God has given knowledge and wisdom to come and empower us on Prudent Women. So, if you are joining us for the first time, Prudent Woman, it's a show where we talk on everything that affects women, anything that women have to deal with in on their daily lives. We talk academic, we talk fashion, marital, finances, everything that affects women. And we are excited because we have been learning. As I said, we started our show somewhere in May this year, and today we're in October. And I would like to believe all of you who have been with us in this journey, you have been learning and you are becoming prudent women. And tonight, as we continue with the show, I'm not alone, and I would like to apologize before we can even go in for what happened last week. We could not go live because our guest had connectivity problems. I hope we are forgiven. And the show that was supposed to have taken place last week was to close our marital regimes. We were to talk on civil marriages. And I would like to encourage all the prudent women who were waiting anxiously for that show to say it is coming either next week or sometime before the end of the year. We will have civil marriages. You know, we communicate with you. We'll be communicating for you to know when it will be coming. But thank you so much. And we saw you joined in multitudes. That to us is encouraging as well. And those of you who were able to send messages to say you understand, we thank you so much. So tonight, I'm excited. I'm not alone, but I have a guest amongst us, an attorney by profession. I have Podu, Mdhluli. She's from Podu Mamabulo attorneys. They are practicing right here in Pulukwane. They are they are doing quite a number of things. They do labor law, they do family law, civil and criminal litigations. So you can go in and talk to them. But for tonight, we are excited because Podu is here to assist us to understand a very important subject, that is wills. Um, Something that all of us we ought to have. Without that, you are not gonna be living a legacy that you yourself desire to live for your family, because you are saying everything that you have worked for, you are leaving it in the hands of someone to take decisions for you. So tonight we're gonna be talking on wills. I trust that you are excited to be learning on it and you're going to be interacting with us. We're looking forward to having you, Sesipudu. May you greet our audience. So, Sesipudu, it's coming. She just had some disconnection, but she'll be joining us. I trust that from what we've been doing on marital regimes, once you saw that we were coming in, gonna be talking on wheels, I trust that you are ready with your questions. I trust that you're going to be interacting with us. Those of you who are watching us on Facebook and those of you who are watching us via YouTube, please drop your questions. We would like to get your questions. This is an opportunity. It doesn't come every day. It's an opportunity of a lifetime to have someone coming in and giving us free legal advice. It doesn't happen every day. And I know sometimes when we're in this type of platforms, you may not be able to ask all the questions that you will want to ask, more especially those which are personal. But I would like to believe that as you interact, it will give you pointers to know how you should go about it. And we appreciate you so much, family, even as we get our things in order. I think Ceci Podu, she just had some technical challenges, but she will be connecting. We were right with her. I do not know what has happened, but she is coming. Get those questions ready. We are going to be talking about wills. It's your lasting legacy. I can imagine all of us ladies on a daily basis, we go up and down, working. And some of us, we even say, I do not have time to rest because I'm working for my children. But if you are working for your children and you don't have a will in place, what are you saying? Do you want a system that you are not sure of to be the one that takes decisions to tell how you should go about your the administration of that very estate that you want to live for your family? For me, I don't think that is fair. And we are in a country that cares so much about all of us. South Africa, October is said to be a wills month, and all different companies, estate administrators, attorneys, all government departments, the justice department, they are promoting free will a month, this month of October. And this is a month where all these professionals are saying you can come and and they help you to draft your will at no cost. And I don't think, ladies, we should be sitting and laying back when we're given such opportunities. So tonight we're going to be talking to our attorney. She's going to be taking us through what a will is, what you need to look forward to, and where you should go to get assistance to draft the will. Ceci Pudu, thank you so much for coming back. We understand you had some connectivity challenges. Welcome. You can greet our audience.
Good evening, Cecile Rhulani, and good evening to all the viewers and the listeners who have joined us tonight. Receive my greetings. It's a pleasure to be here, and I'm excited to be part of this awesome time.
Are excited, and I know the ladies are excited, and we are grateful for you to be here to give us the wisdom that you are about to share with us. We're going to be talking about wills. I would like you, Ceci, to open the show by telling us, in terms of your, in the legal fraternity, what will you consider a will to be?
A will, in simple terms, I would say, is a document, preferably a document. And I know I'm deliberating using the word document because it's preferred or it's encouraged that people write their wills instead of speaking about their wishes upon their death. So it's a document that a testator or a testatrix, which is a person who writes a will, puts all his or her wishes on paper as to what should happen when they pass on in terms of their assets, who they must go to, how they should be administered, in what way, and put whatever conditions, if there are any, in the event there are conditions to those. So that is the final document that will lead those who are living into how the deceased estate should be administered. So it's a document that speaks beyond somebody's death.
Thank you. So you're saying a will is a document. So
Correct.
a will, it's not an oral speech that one records. I'm asking this because I've once seen a movie where the person recorded
Yes.
his will or his wishes for
Mm,
what should happen to his estate. So
yes.
in terms of South African law, When you say you've got a valid will, how should it look like?
Thank you very much. I'm glad you talked about somebody that you've watched, because sometimes we see things that happen on TV and in movies, and we translate or bring them to the jurisdiction of our country. Like I said earlier, when I said it's preferred that a will must be written. So there are instances where one could record him or herself making their final wishes. Now, the court can take that as a person's will. However, what the Wills Act of South Africa recommends or directs or defines as a will, it's that it must be a document that must be drafted, signed by the testator. Each page of it must be signed. If it has more than one page, it must be signed in the presence of witnesses. So it's in terms of the Wills Act, the directive is that a will must be written. But of course, there are instances where a person would speak of their final wishes in a video, and in that instance you can see that the authenticity and the wishes of that particular person, they are not in dispute. Unlike when you are sitting in a meeting somewhere at home and somebody comes and say, on this particular day, my mother or my brother or my father said X, Y, and Z, and that cannot be proved. Or you find that the very same people who were in that particular meeting recollects differently, then that's where the problem is. That is why the encouragement and the advice is that it must always be written, so that there's no shadow of doubt as to what was the intention of the testator when he or she made that particular will. Because as a country or as a people, especially when it comes to the issues of estates, there are a whole lot of disputes that arise in contestation of what the intention of the testator was. So there are instances where the court would accept, for example, that type of a will which has been made in a video, but in terms of a South African law, is that it must be written.
So it should be written.
It
And
must be.
yeah, it must be written. And I would like to believe the best way to comply with the law, it's always to do it the way the law has prescribed on it. So we
Correct.
are grateful. Yeah, so we are grateful, Ceci, that today we understand that it must be written. But
Mm,
what comes to mind now, it's, in our culture,
mm,
when one starts talking about leaving something for someone, we think you're about to die. And I
yes.
would like to believe those are the things that makes us, especially the Africans, not to have wills. Even when you professionals like yourselves, attorneys, we were talking before the show, you were saying you also participate in the Free Wills Month.
Mm,
And as Africans, we're not taking advantage of those because we were told once a person starts talking about we what to leave to who and what, you are
mm.
about to die. So who should actually be able to draft a will, or at what age one should draft a will?
Thank you. Now, in terms of our South African Wills Act, any person of the age of 16 years and above is eligible to draft a will. So, as early as 16 years old, you can be able to tell what should happen with your room, with your sheets, with your pens, with your whatever assets you may have. If you are a trust fund child and things like that, whatever your parents give you, you are able to draft that will. And thank you, Sis Rhulani, because this is a challenge that we have in the African community. One of the things that I do in my firm is administer estate, and it's very painful and very difficult when somebody dies intestate, meaning without a will, because now you leave your children to, in quotes, let's say the wolves, because sometimes you find that the very same people who are supposed to be taking care of your children now are fighting amongst themselves for a piece of your wealth, and not necessarily in the interest of your children, and even in the interest of those children. Our children are different. they have particular personalities, different in their own way. So you find that one particular child is disadvantaging the other children. So when you make a will, you are able to take all of this into account, and you become a responsible person. I don't forget, there was an instance where in my office during one of the administration of an estate, one child was literally swearing at his dead father for the failures that his father made while he was still alive. It was so painful to watch, especially because this child was now left with no parents. The mother passed on before the father, and the father still failed to make things right for these children. So please, our people, and I can tell you, in this year, every year I participate in the Free Wills Week. This year, for first time, I've not had anyone coming in for a free will. Surprising that we do not have that. And our people believe that when they make a will, they are actually bringing death into their doorstep. And that is not the case. It is important. It's what we call estate planning. We need to plan as much as we go to the banks to plan for their education. We go to the banks to plan for, in the event we die, that they should be able to live beyond us. We should be able to plan our estate, how it should be administered beyond our death, without leaving it to families, because practice has shown that even family during death tends to be something else. So we encourage everyone to draft a will at any age. And might I add that you don't even have to have 1 million to make a will. Whatever assets you have, you may think they are minor. People fight even for your clothes, fight for your pots, fight for your mukuku. So whatever assets you have, please make a will. And you can always, every now and again, as you add more to your assets, always review or add on to your will, so that your children or your spouse, especially for those that are even living in the family homes, your spouse can be taken care of beyond your grave.
That you have just given us, it's scary that we can have this type of a campaign and you don't have anyone coming through. And when you go through research, it is said that very few South Africans have got a valid will in place. And
It's
you know, when we were starting, we said, if you are working hard for your family and you do not have a will, you are basically saying, Mina, to me, I translate it like you do not care what happens as long as when you have done your part, you have lived and left. Because what you said, you know, the experience we had in your law firm of the a child who was swearing at his dad, and that happens many times. Sometimes they are not swearing, they're excited, but their excitement lead them to death. You know,
true.
we normally see there's a show, I blew it. Most of
Mm,
the time, you find that I've worked so much, I have everything in place, millions, but there's no will, there's nothing in place, there's no
mm,
estate planning. And my 18-year-old gets 3 million rands deposited in their account. What will happen? Prudent
mm.
women, that will kill your family. That will kill your child. A child with 3 million, I don't think there's any family member that they can listen to. No pastor, no one can make sense into their lives. They will
True
go
that.
off and buy all the brands in the world, and
Mm,
you will have destroyed that which you have worked for with your own hands. And that is not what we are, prudent women. We so much appreciate, and I would like to believe all of us, this is an eye opener. Mina,
mm,
I always say, I joke with my family, I say, as for me, I will rule from the grave. My daughter, legal person, she'll be laughing. She'll say, no, the South African law does not allow. I say, I don't care. I will rule from the grave. If no
true
one
that.
contests, I will rule from the grave. And it gives us an opportunity. A will gives you an opportunity to dictate on how things should go. When I'm alive as a mother, I care about how things are run in my family. Why should I not care how things will be ran upon my death when there are systems in place that have been put in? And thank you. You answered says Portia's question. She wanted to know how many assets should you have before for you to draft a will. And I know that's a myth with a lot of people. Sometimes it's not about the assets, according to my understanding.
Mm,
It's telling what should happen to your children upon your death. Let's say you are a single parent. You can have a will to indicate upon my death, maybe my child should go and stay with so and so. Don't wait for that day after the funeral where the family gathers and then someone raises their hands and say, I'll take the child, and their intentions are not good.
Mm. But also, you must also remember that whatever terms and conditions that we put in our will, they must be terms that are lawful and terms that are executable. Because, for example, if you are living a will with conditions that probably are subject to somebody else's uh, will or contention or acceptance, and without having engaged them on that, that may be a challenge for you. In that person still have their rights to say, I cannot do this, I cannot do that. So whatever condition you make, it will be different. For example, if you say, I leave my entire estate to my child, I direct that he or she must get this assets or this money on condition that he finishes grade 12, or he does he has a junior degree, without necessarily directing that it must be a law degree, because you may find that that child is not interested in the law, but you can dictate that until or unless he or she has done this particular thing, which is reasonable. Because remember, that term that you are bringing on must be a reasonable a term that another person can be able to meet. It must not be an impossible act on a particular person. For example, you can't say you can say that this estate that I'm leaving to my child must not be a part of any existing or future community of property should my child get married. Now that is something that can be done. But if you're saying that my child must get my inheritance subject to the fact that he does not get married, that cannot work. So the conditions, now that becomes very important, that when you draft your will, you must draft it before an attorney who knows the law, who knows what is applicable, who knows what is allowed, what is not allowed, what is unlawful, what is not unlawful, what is lawful. Because then your will be able to stand. Because if you make things that are not going to stand by reason of unlawfulness, then your will not speak for you beyond the grave. And hear me well, I'm not going to, I'm not advocating that we should bring the work to us in the place of the banks. I know people who don't want to pay us as attorneys for drafting the will, because they think we are expensive, and sometimes the bank offers the will for free. Now when you go to the bank and draft a will, they have what we call a pro forma a will, and the person that is assisting you is not a legal person. It's a person who's a consultant, who's going to take your details and whatever. He's not going to make a will custom or suitable to your particular circumstances. Because now when you come before an attorney, for example, the attorney will probe into what kind of a marriage are you involved in, what do you do, are there any even kids outside of the marriage, those type of things will be probed, and they will advise you in terms of how can you be able to draft a will. For example, somebody thinks, now I'm married in community of property, but this woman, I don't want to inherit her because of XYZ. I'm taking everything and giving it to my mother, for example. Now you cannot have that will be implemented after your death, because if you are married in community of property, you can only make your will on the 50% of your estate, because the 50% is not yours to begin with. So if you make your will on the 100% of your estate, that will not stand beyond the grave. So it's important that you visit us as attorneys in drafting those wills, so that even if beyond your grave and your husband or your wife remarries, your children will still be safe. Because if you don't do a will, your spouse will marry somebody else who will come and stay in your home and chase your children away, because they would then be married in community of property, likely with the other woman, and then your children will be left in the cold. So let's make sure that we visit lawyers and draft these wills.
No, that brings us to a very important topic to say what are the exclusions that one should have on a will. And I know the time that we have, it's not enough, But Prudent Women, when you link the marital regimes that we've been talking about and today's session, you will be able to see that which type of marital regime will allow you to do 1, 2, 3, and 4. And I would like us to go on an ad break. When we come back, says Podu, I will request you, let us just talk on the pensions when it comes to drafting wills. I just want us to cite that one because it affects all of us, just for you to give us a clue. But what she's saying is very important. Going to people with understanding of what you are doing is the right thing, because you can do something and think you have done it right and only to find that it doesn't stand at the end of the day. So legal practitioners, financial advisors, those people have been trained properly to understand estate planning. And it's not only on just knowing where to send what, but they will also assist you in calculating issues like tax, something that you cannot run away from, but you can find good ways of avoiding to pay huge lump sums of tax upon your death. Let us go to an ad break. We'll be right back with you.
Ladies and gentlemen, here it is. Streaming 24/7. 24/7.
Bold Moves Radio.
Bold Moves Radio.
Afrika nakupenda sana, oh Afrika nakupenda sana.
Welcome back. The show is Prudent Woman with myself, Rhulani Baloyi. Our guest tonight is Podu Mdhluli. She's an attorney. And you are watching Prudent Women. Those who have just joined us, we are talking on wills, drafting a will to leave a lasting legacy for your family. Podu, we continue with our talk. As I indicated before we went on an ad break, I know there are quite a number of exclusions, most especially depending on different marital regimes and, different settings of one's life. But let me just for tonight ask that we talk on the exclusions when it comes to your pension, on the two, even if you just based on the out of community and in community a marital regime, so that people should understand. Because my observation has been that most of us, when we think of writing a will, especially from our African culture, most of us, we don't have much to leave behind. But one asset that we have is our pension. So if you can talk us through, how do we deal with the pension when we draft the will?
Thank you very much. Now, pensions do not form part of the administration of the estate, even upon death. When you have a pension, you know what normally happens is that you go and of whoever you want to put and the percentages that you put along those beneficiaries, and the pension funds, the trustees of those pension funds decide what should happen in terms of that. Now, when a person dies, whether with a will or without a will, whoever administers their estate will open an estate account. So the pension funds are not part of the monies that will be collected and get into the estate account for administration by an attorney who you'd have appointed in that time. And also the money that's on your life, for example, your life policy wherein you have not made beneficiaries. That's why when you go and you claim, they will tell you, no, so and so has been appointed as a beneficiary. That money goes directly to that particular person. So it does not come into the estate, but everything else that is yours, your patrimonial assets, the monies that are in your account, the investments that you have not made with beneficiaries, they will come into your account. Now, when you are married in community of property, you can only make, the exclusion is that you can only make your will in terms of the 50%. And let me start by saying, people who are married in community property, they can decide, have an option to decide whether they do a joint will together, wherein they can appoint each other as an executor or executrix upon a death of another person, and they also make their inheritance to their children in a particular way while they are both still alive. Let's say, for example, they would say, upon my death, everything else will devolve, will go towards my husband or my wife. And then upon the death of my husband or my wife, this is what should happen to our children. They can do that, both of them at the same time, with one attorney, if they so wish. Alternatively, if they don't want to do that, they can also do their separate will, separate a husband will there and a wife doing the will there. So it depends on the preference of the parties. Now, if you are married out of community of property, you don't tell anybody about your will. Even when you're married in community of property, you can only consult in terms of whether do you want to do a joint will or we do our separate. You don't need that to be able to draft your will. So, for example, let's say you find that the family has decided in their estate planning that we are creating a trust for our children. Now, you cannot ever have a trust without a will. So, as you create that trust for your children, you need to have a will wherein you will determine what should happen to your beneficiaries. So therefore, you'll be forced in a way to do a joint trust if both of you are founding trustees of your children, because nowadays people are choosing to have a trust created for their children, but you cannot have that without having drafted a will. And most of the time is done as a joint will for the benefit of your children. And the other exclusion would be, for example, if you have inherited something from somebody, whether your parents were in a marital regime of community of property was an exclusion, or maybe you find that they are also sentimental value items. There are people which I see in other nations or in other races where you find that you receive sentimental jewelry, sentimental ornaments, and things like that, which have been excluded by virtue of inheritance. They don't form part of your estate. So you cannot include that as you draft your will, amongst others.
And something around issues of a trust. And I've heard that it's good to have a testamentary trust so that you don't find yourself where you are leaving millions before your children. Maybe if you can take us through the benefits of having such a testamentary trust, and also link it up with how do I now nominate beneficiaries who are supposed to be the beneficiaries on my will.
All right, thank you. Now, a trust, a topic is a topic on its own, an entire topic on its own, because we've got different trusts that one can be able to choose from. Now, a testamentary trust that can be done, it's a living document, or it's a living provision that even happens while you are still alive. It's not dependent upon your death, unlike a will. A will only comes into the picture upon your death, but a trust for your children is a living thing that can even exist and benefit your children while you are still living. That is the difference. And that trust can be able to have assets of its own, register assets of its own. For example, if you buy a house in the name of the trust for the benefit of your children, you can do that. You can transact through that trust. So that is the difference between the two. Now, in terms of the beneficiaries, as to who you choose in terms of your will, you are not obligated by blood or by the fact that I gave birth to my children. It does not automatically mean that I will inherit them. Inheritance is a choice. Now, it may happen that a father or a mother decides to disinherit their very own children. And once that is done, that will still be valid, because it's a choice that the testator made. It does not become automatic that because I've given birth to these children, or because I have a particular spouse, therefore it is a must, it's obligatory for me to inherit them. Inheritance is choice of a testator. I know of people who have taken the entire estate and given it to institutions while their family members are there. Because remember, when you inherit somebody, it must be for a particular reason and a particular purpose. And others may feel, because of maybe relationships that went sour or that went strained, that they want to disinherit. The same way, as you draft your will this particular year, you may have particular beneficiaries. 2-3 years on the line, you can still change your beneficiaries. It is up to you. And if you disinherit your children, and upon your death they find out that you actually gave the next door neighbor your estate instead of them, they cannot successfully contest that will on the basis that the person that is inheriting is not related to us. They cannot successfully do that, because it's not an obligation that people who are related by blood should inherit one another. It is one's choice.
So that brings us to one hot topic that we had previously with our guest when we were talking on marital regimes. She indicated that our law in South Africa nowadays does not have what we as people on the street talk about illegitimate children. And I would like to find out, maybe to say with what you have just said, it means one, it's at free will to also enlist such children, whether you know them or you do not know them, as beneficiaries in their will.
Definitely, you can actually do that. And for example, sometimes, and this happens a lot, that you find that those children that are outside of the home, they are normally the younger ones, and because they are younger ones, they usually get the more percentage, and that's what drives the wives most of the time up the roof, because they're like, but these ones are even outside, but they're getting more percentages than my own who are in the home. Now, with children, in terms of the will, you can give whoever you want to give. Now, I want to turn it flip side in terms of the Interstate Act. In terms of the Interstate Act, if you die without a will, every child, and this unfortunately is not discrimination, prudent women, it usually happens with men, that you find that all the children are brought by your aunts. You will find that they will come and bring the child from Kamdabula, the child, they know about these children. So every child of the deceased, in this instance would be a deceased husband or father, they will inherit equally with the children born in the house, if the person died without a will. Now, if they die with a will, then they can decide how they want to inherit those children. So you as a wife cannot now come and say, but I don't know about this particular person, I don't know about this, how can this man betray me like this? Unfortunately, it's not up to you. It is the choice of the testator as to what happens with their estate when they die.
For those of you who have just joined us, the show is Prudent Women. You are with myself, Rhulani Baloyi. Tonight we're talking on wills, and I would like to encourage those of you who are watching us on Facebook. We've been saying we're asking you to tune in on YouTube, on our YouTube page, that's Bold Moves Radio, and please subscribe when you are there. We are in a process of phasing out streaming through Facebook, and we appreciate, I see a lot of people tonight, you are joining us on YouTube, and you are also welcome to drop your questions on YouTube. Podu, when you were telling us about the will, you spoke about an executor, a testator, a testatrix, and an executor. How now do I appoint an executor? I've had a number of people who went to the bank, as you said, that at the bank they just have a template, and they found it much more difficult to now get the will to be executed. So how do I now appoint an executor? Who should be the right person for me to appoint? And how do I make sure that my family members are aware that there is a will in place?
All right, thank you very much. Yes, actually earlier when I talked about going to the attorneys, it's one of the things that I wanted to point out, that when you appoint a bank when you draft your will at the bank, they will usually appoint an executor. They appoint themselves rather as an executor in your estate. And what we have seen is that everyone who has done their will with the bank, they struggle. Their estate takes forever because you find that they appointed ex Van Veek somewhere who sits in Gauteng and whatnot and whatnot. And for them to be able to go to the master to open an estate for you and for your estate to begin to run, it can take years. Whereas when you go to an attorney's office, an executor is somebody that you choose yourself. It can be a family member, it can be a friend that you trust, or it can be an attorney that is actually assisting you. Because remember, when you die, when your estate have to be reported to the master of the high court, depending on the value of your estate. If your estate is below 250,000, there is not going to be a need for an appointment of an agent who is going to administer or assist the executor if your executor is not attorney in administering your estate. So you can report your estate to the master of the high court, and they will give you what we call a letter of authority, and you go and close the banks and collect the monies that are there and do whatever without the process that is required when the estate is beyond 250,000. Now, when your estate is beyond 250,000, when you go to the master to report, they will say, go and appoint an agent who will assist you. Now, if your will has an executor who is an attorney, it makes it even easier for you, because that particular person, upon the notification that you have passed on, they will immediately open an estate for you, open the file for you, do an estate account and lodge the estate, do a notice to the creditors, eventually do a liquidation and distribution account, which is a process that master allows to be done in 6 months. Now, like I said, it can be anyone that you trust. It can also be your attorney who is drafting your will. And if it happens to be an attorney who's in your will, you can also have a condition to say, in the event this particular person, be it your attorney or be whoever you've appointed, dies before me, then I appoint so and so. For example, in my family, it will be I appoint Podu Mdhluli, the senior practitioner of Podu attorneys. In the event she dies before me, then I appoint a senior practitioner in the employ of Podu attorneys, or whoever you may choose to appoint. Now, when you do that, it makes it easy for you. And the executor, mind you, cannot be a beneficiary if you decide to appoint somebody who is related to you. There are those who also prefer to appoint an executor who's also a beneficiary. But my recommendation is that let the executor not be somebody who's also a beneficiary. And that executor is also going to be entitled to what we call 3.5% of your estate, whatever the total of that estate is. So just know that that particular person will be able to do that. And in your will, when you appoint that particular executor, please also mention that that particular person should not be allowed to furnish what we call security. Because if you don't have that clause that that person must not supply security, then, for example, if your estate is worth R1 million, the master of the high court may require that person to furnish security so that they are confident that this particular person will administer your estate in the best possible way without prejudicing your estate. Now, that may make it difficult for a person whom you have appointed without exclusion of that security, that it is going to be impossible for them to administer your estate.
Try to run away from. And I think this is something that makes us not to want to draft wills, because you're trying not to think about all these requirements, because now you are bringing in the monetary element. I have heard from my financial advisor that you can plan your estate, put down your will, and be able to calculate the 3.5 that you're talking about, and be able to have products in place to cover for such things. And when I had a conversation with him, I remembered something that has been with us for a very long time. Back then, we used to have shops in the villages, and we will always say, when the owner of the businesses die, he dies with his things, and we attributed it to witchcraft. And I finally realized that there was no witchcraft; it was poor planning.
True. True
There's no
that.
witchcraft, it's poor planning. And
Mm,
with what you're bringing in, I would like you to just talk on it for the prudent women, because it's very important. We work and we live all these things, but we're not thinking of that 3.5. We're not talking about the tax element that
yes.
has to be paid. And the clause that you have just mentioned now, it's very important, because you find that you have appointed someone that you trust, but they do not have the money to be able
True.
to put that in as security. So that's
Mm.
very important. So if you can just touch for us to explain, when you say 3.5%, is 3.5% of what?
All right. Thank you very much. And I think you captured it very beautifully, Sis Rhulani, because as we live as parents, it's important to draft a will, but there's no point in drafting a will with nothing but liabilities, because when a person dies, the first thing that we do, we pay the liabilities, we pay the creditors before anything can be inherited by anyone. Now, if what you are leaving behind is death and no assets, unfortunately, your children will not inherit anything, because we first pay the debts. After paying the debts, we pay ourselves the 3.5%. We pay the administration cost of the estate. Like I said earlier, we find that you have to advertise in the newspaper, national newspaper, also or whatever review and whatever. You advertise in the government gazette for the creditors first. You also have to advertise again for the liquidation and distribution account, and you have to make it live for inspection in the master of the high court or the magistrate court near you. So that's what happens when we say things go with the parents. Unfortunately, it's not them going, it's that the parents failed to plan. So instead of buying 6 cars which are not paid off, rather pay 1 car and have 2 cars which are paid off, so that your children can remain with something. Especially because if the money at hand is not able to pay for the debts, we sell whatever is there to pay off. We can inherit the children without having sorted out the that is a lie. There's no such a thing, or there's no such a thing. We will pay the debts with the money that is at hand. If it's not there, we will sell even your home, if it means that, because we will not inherit your children without having paid the creditors. Now, the other thing is that when you have an estate, it's not the actual money that you have at hand. We calculate the assets. Let's say, for example, you have a particular house that is in a particular suburb. We'll evaluate it. We appoint an evaluator. We'll evaluate your entire immobile properties, your movable properties, all of them, vehicles, furniture, and household effects. If there's money coming in, claims, what we call claims in favor of the estate, and we take all of that, we take them as a total of the assets. Now, that total of the assets, we calculate the 3.5% of that. So if you have a house worth 3 million, you have cars which are worth 2 million, you have whatever household furniture effects, the 3.5% of the total assets as the time of death, that is what we calculate. So that the total, the 3.5% comes from your immovable, movable, and claims in favor of the estate. So if you have a policy that paid 5 million, that paid 10 million, we include that. The 3.5 is calculated from there before the payment of liabilities, before payment of the administration costs, before payment of everything else. So that is how it is calculated.
5% of a whole lot of things.
Yes.
So scary. Because then
And
I was
not,
gonna say,
not only that, the estate act also, the estate act also allows for attorneys to charge what we call 6% of the collected cash after death. So it may be, it will depend on the attorney that you're drafting the power of attorney, or when you do your estate. Others will say it's 3.5% only, and only 6% if or when if you terminate mandate before, I will charge the 6%. Others, they will say it's 3.5% as well as the 6% collected cash. So it differs from household to, or law firm to law firm, not household, law firm to law firm. But the 3.5% is like your VAT, which is 14%. If tomatoes is 14% VAT, it cuts across. VAT is VAT for whatever asset that they are.
But these things should not scare us, prudent women. I think that's why we are here, so that we get to know and understand these things. With proper
make
planning,
informed
we can
decisions.
be able to make provisions for this. As I indicated, my financial advisor told me there's a product, a life, an insurance that one can take to be able to pay for such things. And I think it's when we know that we're able to make intentional decisions on what we need to do. And I see our time is running so fast, and I see questions here. Sesi Itan is asking, what happened when both the owner of the will and the beneficiary dies at the same time?
It's a very unlikely scenario that would happen. But let's say, for argument's sake, it happens that the mother and the child who are supposed to inherit, they die at the same time, and obviously the will cannot be able to be executed as at the time because the beneficiary and the testator, they are not there. What we go in, then we'll have to go into the issue. How do I put, if the child has children, it will devolve upon the children of that child who was supposed to inherit. If we don't have that, we go to the nearest family member. So it means that the Interstate Succession Act will then have to kick in, taking into account the nearest family members. So if the mother and the child were the only ones in the family and there's no one else, we go to the parents of the mother. And if the parents of the mother are there, we go to the siblings of the deceased mother. And in that way, up until we find somebody else who can be able to inherit next in line, the Interstate Succession Act makes provision in terms of that. But it's something that is really likely.
Mm-hmm. You know, we getting to understand that a will is a very important document that one must have in place. I would like us to, like you, Ceci, to tell us how often should one review this document? Because I like to believe if it's a document, I cannot draft a will when I'm 18 years and leave it there. And then I die when I'm 75 and we use a will that I've drafted when I was 18 years.
Yes, definitely. I think the frequency thereof is not really legislated or is not provided for in terms of the law. I would advise that as much as you have it, always review. If you are able to do it yearly, but there are also circumstances that are different to different people. You find that in a year you've not made any improvements to your current estate. So every time there's an improvement or there's a change on your estate, amend or review your will. So it should happen all that is an improvement or the circumstances change. Let's say, for example, somebody loses the child or loses a husband, and they don't change their will. It's very difficult. I see we have a limited time, but I would explain the story of somebody that had inherited their mother and their mother died before them. And when they died, it was even difficult to bury them because the people that remained could not even have access to the money that she had because the person that she had nominated died before her. And unfortunately, she did not review her will. So as and when your circumstances change, be it your relationship status, your change of patrimonial issues, please review your will. That the frequency is dependent on the improvements or the changes in your relationship.
I've come across a number of people who divorced, did not change their things, and a few years down the line, they pass on, and only to find that the ex-husband or ex-wife is the one who benefits. And I became so inquisitive. If you can take us through that law that the grace period where after the divorce, how long should one stay before they change? How does the court treat it when it comes to divorce, and whom you have nominated to be beneficiary?
Now, the court only takes in terms of it's governed by the Wills Act. It talks about 3 months, 3 months period after the dissolution of the marriage. The court says the will should be administered as if the person died before the dissolution happened. But otherwise, beyond that, then the will be implemented as it was. It will be taken as though the intention of the testator was to disinherit the surviving spouse. The period is 3 months in terms of the Wills Act.
And prudent women, I found that scenario to be very sad. And in most cases, it's things that can skip your mind, because when you go through life events such as a divorce, you tend to be very emotional, you are drained. But it's still very important for you to be awakened to the situation and understand how you should go about your issues. As she said, that life-changing events should dictate to you to go back and change the will. But I also, as Podu, I would like to bring to the prudent women. I know women were very emotional beings. Let us not be angry tonight and tomorrow I go and change my will. And then tomorrow, when something, I go and change it. But we need to be intentional. So I think it's important. Let us change the will when we have life-changing situations in our life, and it's much appreciated that our law, you see, the people who draft the legislation of our country, I tend to say they're very sober, because they understand that when you go through divorce, you are emotional and you are angry. So within that first 3 months, it may be very difficult for you to go and change. So you are protected. But let us not use it to be a punishment, a will now. Every day you go and change, because now instead of it being a blessing to be able to leave a lasting legacy, it can even destroy your relations in the family.
True.
Our time is gone, and I see ladies are still talking. But I would like to believe, as we said, October was Will's month. October is not yet over. We still have this coming week. If you go on different platforms that are talking about wills, and I think even our government is doing its best to educate people to take to draft wills, because it becomes a burden to the government. Because if you do not have a will, it means you are dying interstate. Then it's government, it's the courts that must take decisions on your behalf. Something that I do not believe it's what we are looking for, but we would like to make our voices heard on how things should go. Most especially, we care about our loved ones. So, Sipodu, we cannot thank you enough. We so much appreciate